Hello everyone, thank you for joining me for Secrest Wardle's complimentary series of my PIP Monthly for the August 2018 segment. My name is Javon David. I'm an attorney and partner at Secrest Wardle's Troy location, and I'll be going through some cases and some interesting topics that are trending in PIP litigation this month. We'll go through a couple cases pertaining to fraud and res judicata that were issued from the Court of Appeals. In addition, some of our viewers have submitted various topics that they want us to talk about or provide a detailed overview for some of their claims adjusters or for themselves. So this month we've picked a topic that was posed to us by one of our listeners, and that's the discussion of talking about biomechanical engineers and using biomechanical engineers as a pre-suit tool for claim handling, and exactly what the pros and cons of using a biomechanical engineer at that phase in a claim would be, how it can help you in your investigation of a claim, and essentially what the impacts would be in using a biomechanical engineer in litigation. Let's get started with the Court of Appeals update. The Henry versus State Farm case, which is an unpublished decision, goes through res judicata in a first-party action. And it also included an underinsured motorist claim, which was the point of contention in this lawsuit. So the lawsuit stemmed from a motor vehicle accident that occurred in March 2012. At the time of the accident, it was alleged that State Farm's co-defendant, Charles Johnson, who was the tortfeasor, was the uninsured operator of a vehicle owned by his employer, Metropolitan Cab Company. It was further alleged that plaintiff was insured by a personal policy with State Farm and by his employer's policy through Sparta Insurance Company. At issue was coverage of $40,000 from Sparta and $100,000 from State Farm for uninsured motorist protection, as the alleged tortfeasor was again uninsured. So there's kind of a complicated and convoluted procedural posture of this case because several lawsuits were filed. So I'll just go through that and take you through each suit that was filed. So in June 2012, plaintiff filed suit against State Farm, asserting State Farm breached its contract for failing to provide underinsured motorist benefits. According to counsel for plaintiff, counsel for State Farm represented to him that Johnson was in fact adequately insured. Thus, at that time and after those representations, an order for dismissal with prejudice was entered, dismissing State Farm from the case. Then in September 2012, plaintiff filed a second lawsuit against State Farm, this time seeking only personal injury protection benefits. In November 2012, just a few months later, the court entered a stipulation and order dismissing State Farm from the lawsuit, but this time with prejudice. So the first suit for underinsured was with prejudice. The second suit for PIP benefits was without prejudice. In June 2013, the plaintiff filed a third lawsuit against State Farm, again asserting that State Farm was liable for underinsured and uninsured motorist benefits. In the third lawsuit, State Farm moved for summary disposition, arguing that plaintiff's claims were barred by res judicata. The court entered an order dismissing the claim with prejudice and ultimately granting State Farm's motion for summary disposition. Essentially what happened here is that these prior orders that dismissed the claim with prejudice was used against the plaintiff to bar her ongoing claims against State Farm. After the court dismissed her third lawsuit, the plaintiff got a little creative and filed a motion to reinstate that first 2012 lawsuit against State Farm, arguing that the order dismissing State Farm with prejudice should be set aside because of the mutual mistake among the parties. Remember, that was the situation where the plaintiff attorney and the defense attorney had some conversations, and it was represented that the person that was allegedly uninsured was in fact covered by insurance. Plaintiff also filed a second suit to reinstate her lawsuit. However, no written order was ever entered setting aside the 2012 order dismissing State Farm with prejudice. So for unknown reasons, per the record, the parties essentially stipulated to dismiss the June 2013 complaint without prejudice. 2 days after that dismissal, plaintiff filed another lawsuit against State Farm for a fourth time, again bringing claims for underinsured and uninsured motorist benefits. State Farm, yet again, filed for motion for summary disposition, arguing that the claim was barred by res judicata. The trial court heard oral argument and expressed confusion as to the procedural status of the claims And during that hearing, counsel for plaintiff represented, without any actual real proof, that the trial court had already set aside the 2012 order dismissing State Farm from the case. Overall, the trial court refused to apply the procedural facts as res judicata, concluding that it had somehow already set aside the 2012 order at issue, which was not true. So the lawsuit continues, and in March 2016, State Farm files yet another motion for summary disposition against the plaintiff. This time, State Farm argued that plaintiff's claim was barred because she failed to sue Sparta as a condition precedent for recovery under the policy. In response to that motion, plaintiff filed a fifth lawsuit against Johnson, who was that tortfeasor, and for the first time against Sparta Insurance, who was the plaintiff's employer. In November 2016, Sparta filed its own motion for summary disposition, arguing that plaintiff failed to file suit within the statutory period, and they were ultimately dismissed from the lawsuit. At the same time, State Farm moved for summary disposition, arguing that, number one, benefits under State Farm's policy were excess to Sparta's primary policy, and number two, that State Farm's policy required plaintiff to exhaust any primary coverage. And finally, State Farm argued that because plaintiff failed to exhaust benefits from Sparta, she was now barred from collecting under State Farm's policy. Now, the trial court agreed with State Farm and granted summary disposition. The plaintiff appeals, and the Court of Appeals, despite all this procedural history, took a large focus on the res judicata issues and really performed their analysis based on res judicata. Specifically, they defined the necessary elements for a valid res judicata claim as follows. Number one, that the prior action was decided on the merits. Number two, that both actions involve the same parties or their privies. And number three, that the matter in the second case was or could have been resolved in the first. The court explained that Michigan law defines res judicata broadly to bar litigation in a second action, not only to those claims actually litigated in the first action, but to all claims arising out of the same transaction or occurrence. And it applies to claims that the parties could have litigated but did not litigate. Here, when the Court of Appeals was reviewing the cases, they determined that a same transaction is determined by looking at the same issues that are being presented, how close in time the facts are related, and quote, time, space, origin, or motivation, and ultimately decided that the claims at issue here were barred by res judicata because that 2012 order was never set aside. Now, ultimately, the Court of Appeals looked to the entirety of the lawsuits, the chronology of the events, and hung its hat really in making its decision on that prior order that dismissed the claims with prejudice. And you always want to look, when you have multiple lawsuits, especially in a first-party claim or any lawsuit, to see what exactly happened in the first lawsuit, what claims were barred, what claims were litigated, and what is at issue in this lawsuit. Do you have a res judicata defense? Is there a prior order in place? These are all things that you want to look at in handling a second-generation first-party action, or even in handling an underinsured or uninsured motorist claim that was either, tacked on to a first lawsuit or never really reached or refiled and brought against you. Because you can, use the with prejudice language or even with the without prejudice language to get these cases dismissed or shaved down in part. So let's say there was a full dismissal of household services or attendant care with prejudice or something like that. You can try to make the argument. It's a little trickier because with PIP, obviously the expenses have to be incurred in order to be compensable. But you can still check to see if any portion of the claim, such as causation or anything like that, is barred by res judicata. So keep that in mind when you're claim handling, and if there's a prior lawsuit or prior dismissal with prejudice, check to see exactly what that barred. Was it just an underinsured, uninsured motorist claim? Is it an attendant care claim that the plaintiff is trying to include in this lawsuit as well? You want to go through all those things so that you can quickly shave down the case and get to the heart of the issues. Now, the second case from the Court of Appeals this month is certainly less convoluted than the last case. It's the case of Petros versus Everest Insurance Company. And this case involves a nice discussion of fraud and rescission and failing to disclose information in the application for benefits. But more significantly, this is a nice case that came down after BASI was decided. So we'll go through that once we kind of touch on the facts here. So in Petros versus Everest Insurance Company, the plaintiff obtained automobile insurance from Everest through an application of insurance sometime in September 2015. 3 months after obtaining the insurance, plaintiff was rear-ended and made a claim for first-party benefits. In reviewing plaintiff's application for insurance, it's important to note that it required disclosure of all household members under the age of 14. That included anyone, spouses, roommates, children, essentially anyone who could potentially drive the vehicles that were to be listed on the policy. And the policy also clearly indicated that the premium could be affected by any information that was or was not disclosed. So plaintiff's application here indicated that he was the only listed driver of the vehicle and that he was the only household member over the age of 14. In addition, the application included a signed statement from plaintiff agreeing that intentional concealment or misrepresentation of material fact would void the policy. So a lot of that is typically included in most applications for insurance. It just says, I understand that I am providing this information. The information is truthful, and I recognize that the repercussion for providing a misstatement or a falsehood is the policy could be void. So after the accident, there was an investigation into the claim, and it was revealed that plaintiff was living at his mother's house and that the address that he listed on the policy was his mother's address and his stepfather's address. But he failed to disclose these individuals, which resulted in a lower premium. As a result of those findings, Everest then sends out a letter to the claimant explaining that this was a material misrepresentation and that the policy would be rescinded. The plaintiff's premiums were returned to him. Plaintiff thereafter filed suit seeking first-party benefits, and he testified at his deposition to the following. Number one, he confirmed that he was living at his mother's house from the time he obtained his license through the date of the accident, including the time he completed the application for insurance. Number two, the plaintiff testified that he lived at his mother's address with several household members over the age of 14, including his mother, who was over 60, his stepfather, who was over the age of 55, and his sister, who was 20 years old. He then testified that his mother, stepfather, and his sister, all individuals over the age of 14, lived at the home since 1997, so long before the accident. The defendant moved for summary disposition after the deposition of the plaintiff, arguing that it was entitled to rescind the policy because there was no genuine issue of material fact that the failure to disclose all household members was a material misrepresentation that resulted in fraud or fraudulent misrepresentation. The trial court denied defendant's motion, reasoning that rescission was inequitable and that the plaintiff did not act recklessly in filling out the application for insurance. Defendant then files a motion for reconsideration, which is denied, and that's how we get to the Court of Appeals. The Court of Appeals noted that the correct legal standard was the very straightforward analysis that we all know of the evidence supporting the elements of fraudulent misrepresentation and assessment of whether the plaintiff presented evidence rebutting those facts, thus presenting a genuine issue of fact for trial. The court then looked to the Titan versus Heighton case 491 MISH 547 and noted that in order to prevail on a claim of fraud, an individual must establish, meaning the defendant here, that the other party made a material misrepresentation, that the representation was false, that the party knew the representation was false or made it recklessly without any knowledge of its truth and as a positive assertion. Number 4, that the misrepresentation was made with the intention to be acted upon. Number 5, that the party claiming fraud, the fraudulent misrepresentation, acted in reliance on that misrepresentation. And finally, that an injury was suffered as a result. In this case, Petros versus Everest, the court concluded that it was undisputed that defendant satisfied the elements of fraudulent misrepresentation, thus entitling it to rescind the policy ab initio, meaning at inception, and secure summary disposition. The court, in so ruling, found that plaintiff made a misrepresentation when he signed an affirmative statement in his application indicating that he was the only household member over the age of 14 living at his mother's address, when we know from his deposition testimony that that is not true, and that he had his mother there, his stepfather there, and he had his sister, all adults over the age of 14, who were living with him not only at the time that he had signed the application for insurance, but also in the decades before. The court goes through a nice analysis of the elements of fraud, but ultimately determines that the trial court erred in denying defendant's motion for summary disposition and applied a wholly incorrect legal standard, that the facts were so clear that summary disposition was warranted. Now, this case is significant in a post-Bazzi world, and the Court of Appeals reiterates the proper legal standard for a trial court's determination of summary disposition in first-party cases where there's fraud in the application for insurance. Just a quick plug here, if you want an overview of what Bazzi stands for and what happened there, last month's podcast focused on this, and also my partners, Renee Townsend and Mark Masters, created an entire webinar that goes through the ins and outs of Bazzi, which actually happened to be a case that was handled by Secrest, Wardle, and Mark Masters specifically. So this Petros case is an unpublished decision, but it operates to define and limit the application of the, quote, balancing of the equities that were set forth by the Michigan Supreme Court in Bazzi's decision. Specifically, the Petros court rejects the trial court's assertion of an inequity and in the face of a first party's claimant's undisputed evidence of fraud in the application of insurance. Although the court does not necessarily elaborate on the concept of inequity, it's actually a good thing because the Court of Appeals focuses on the correct summary disposition standards set forth based upon long-standing case law regarding fraud and rescission, and denounces the trial court's reasoning of quote-unquote inequity and quote not reckless as the incorrect standard. The court affirms defendant's entitlement to policy rescission ab initio or at inception in cases where the evidence of plaintiff's fraud in the application for insurance is undisputed. Again, this is a wonderful case for the defense on helping to explain to trial courts on motions for summary disposition based on fraud that the Court of Appeals had an opportunity to apply the Bazzi case from the Supreme Court. This is how they've applied it, even though there's the quote-unquote balancing of the equities that Bazzi talks about and touches on. Fraud elements are satisfied when there's undisputed evidence that a person made those material misrepresentations, and summary disposition is warranted in those situations. For the trending topic in Michigan PIP this month, we had some interest in discussing the use of biomechanical engineers, either in the pre-suit level or even in litigation. Once the suit has been filed, you can still decide to use a biomechanical engineer if you have some questions about the mechanism of injury and the causation issues that may arise. Just a brief overview, a biomechanical engineer is basically a subspecialty of mechanical engineering with a focus on biological systems. It's a subspecialty that requires the requisite science background and the mathematical and engineering background in order to be qualified as a biomechanical engineering. Some schools, in fact, many schools have this as a subspecialty and major, but typically you'll see a lot of the experts will have the mechanical engineering bachelor's degree and then have either a master's in biomechanical engineering or do some sort of additional training on top of their mechanical engineering background and experience and schooling to get that recognition as a biomechanical engineer. And that's important because when you're picking who you want to use, you want to go with somebody that is going to, first and foremost, be qualified to testify if the case ever goes to trial and will be difficult to impeach given their credentials. So before you retain any kind of biomechanical engineer, you're going to want to obtain their CV, review it, have some sort of idea as to what exactly you're looking for before you even retain them. Do you want somebody that has the accident reconstructionist background? Do you want somebody that was a practicing engineer? You basically just want to think about your claim as a whole and decide what kind of expert you would want if you're going to be the one deciding early on in claims before it gets to litigation, whether or not to retain a biomechanical engineer. Now, people always wonder, what is the difference between an accident reconstructionist and a biomechanical engineer? And there are people out there, typically retired police officers, who will come and try to testify as to an accident reconstruction after they've been investigating car accident scenes for several years. But biomechanics is a little more specialized and has more of the science background, the engineering background, and the ability to perform a holistic study of what exactly happened in the accident, what happened to the person's body and the impact, and importantly, what effect did any safety restraints have on the forces that were coming into the body. So they'll look at whether or not there was airbag deployment. Did that help the person at all? Did they sustain less of an injury because of the airbag deployment? Were they wearing seatbelts? What kind of headrest did they have? Did they have curtain airbags, or did they just have front airbags? All of that goes into the factor as to how this person was hurt, if at all, in an accident. But it's important to understand before you even retain a biomechanical engineer what they can and can't do. And oftentimes I'll see my adjusters retain a biomechanical engineer pre-suit very early on in a case if they have questions about the severity of the impact. Normally, they'll get information about an accident that on its face seems relatively minor. We see it all the time. No injury listed on the police report, no emergency room treatment, no EMT called to the scene. The person didn't treat for a while, and then they submit photographs of their vehicle, or the carrier goes out and performs an inspection to fix the vehicle for the collision side of things. And there's very minimal damage, like $500 to $700 sometimes, or even less than that. But then the claims start trickling in, and they're suddenly starting to treat, and they have a lot of medical expenses, and they are now seeing a neurosurgeon and or different specialists. All these things happen in the length of a claim that raises questions in the adjuster's mind as to, wait a minute, I thought that this person was involved in a very minor impact. I'm not sure why they're now treating with a neurosurgeon who's a specialist, who's may or may not recommend surgery for this accident. So in those situations where something doesn't seem to make sense on the surface, but if you're not having the medical background or the biomechanic background to really assess that claim, you want to retain a biomechanical engineer or some sort of expert. Just as you would retain an IME doctor to look at someone's orthopedic injuries pre-suit, or to comment on any kind of physical therapy and injections that a person may be having, you can turn to the biomechanical engineer in that regard as well. And I can just give an example. I've got a case now where someone has a very minor accident but was hospitalized with multiple orthopedic injuries and fractures, and the claim was completely not at all what you would expect from a minor accident. So the adjuster went through and said, I have some questions about this. I need to consult an expert, hired a biomechanical engineer. Turns out that the person was involved in the accident at maybe 10 miles per hour at best, no airbag deployment. So there may have been some other issue that happened between the long time between the accident and the time they were actually seen in a hospital. Turns out that person had fallen down a lot of stairs, ultimately is what was determined. But the point there is that when the initial claim comes in and there's some treatment thereafter that seems out of proportion as to what you would expect with the minor motor vehicle accident, to assist you in your claim handling, you have the resource to use the biomechanical engineer very early on. And that'll answer those questions for you as to, well, this seemed like it was a minor accident. It didn't seem like this person would even need treatment. And in fact, they didn't treat for some time. So understand what a biomechanical engineer can and can't do. So with all that being said, you're still going to need your medical experts. You're still going to need a doctor to help answer any questions you may have about relatedness or reasonableness or treatment or things along those lines. The biomechanical engineer isn't going to be able to comment on those things for you, but what they can do is provide a full picture as to what exactly happened in the accident, what was the mechanism of injury, how much force was exerted on the person's body And were there any mitigating factors such as the airbag or the seatbelt that would have lessened the amount of force and that would have caused this person to not sustain any injury at all, or maybe only sustain whiplash? They are an additional tool. They're a supplemental tool. But again, you need to understand that you can't just have the biomechanical engineer. If you're questioning causation or relatedness or things along those lines, you'll want to likely have a biomechanical engineer in those low impact accidents, coupled with any medical doctor that you would require or need to assist in your adjustment of the claim. When is the best time to consult with a biomechanical engineer pre-suit? That just depends on each case. Claims are handled on a case-by-case basis. And if there are questions in the adjuster's mind as to how this minor accident could cause a head injury, or how this accident could cause disc bulges that maybe necessitate treatment with a specialist or a surgery, those are times that you might want to reach out and consult with a biomechanical engineer. Now, you can send them the medical records, you can send any examinations under oath or recorded statements of the claimant so that they get a full picture as to the facts and circumstances surrounding the accident and the treatment thereafter in developing their whole model as to what exactly happened. Many times, in order to complete the investigation, they'll want to see the vehicles and inspect the vehicles if they're available. And I always highly recommend doing that because they can get the data from the vehicle and perform a holistic kind of overview as to what happened in the accident, where was the force, was the greatest point of impact in the back of the vehicle or the front of the vehicle, or what exactly was going on there. So in working with your biomechanical engineers, you'll want to assist them in locating the vehicles, working with the claimant to inspect the vehicles, and trying to find and locate the other driver to get that vehicle as well. You'll also want to provide them with the medical records of the claimant, the examinations under oath, or any recorded statement. If it's in litigation, then you certainly want to give them the deposition transcripts of not only the claimant or the plaintiff, but any witnesses to the accident, any witnesses or people involved in the collision, just so that they can answer any questions about what went on in the impact, what other forces were causing or contributing to the issues there, and whether or not the person did or did not, in fact, sustain the kind of injury that they're claiming. Now, you can use the biomechanical engineers for not only orthopedic issues, but for head trauma as well, especially in cases involving concussions or mild traumatic brain injuries, which is another term for concussion. That term is often used interchangeably. So a concussion can typically be difficult for medical doctors to diagnose because of the lacking objective evidence. But when you use the biomechanical engineer, they'll be able to look at the force and the interior of the vehicle, the kind of vehicle, to see, is this the kind of impact that would have caused the body to go forward and then back and then have the person strike their head on something in the vehicle, also known as whiplash. These concussion type injuries, these mild traumatic brain injuries, the biomechanical engineer would be equipped to assist you in assessing whether or not that was viable or whether or not that's something that could have happened given the forces that were at play. Now, I often get a question as to whether or not we should request a written report from the biomechanical engineer, and it depends. If it's in litigation, you don't always necessarily want to get a report. There's not a hard and fast rule. It just depends on what this person is going to do for you and how you plan to use them at trial. It gets a little trickier pre-suit because if you are going to use the biomechanical engineer coupled with your medical experts in assessing a claim and adjusting a claim, then you probably do want a report. But that's something that you need to decide as you are adjusting the claim, reviewing the medical records, and working with your biomechanical expert in completing your investigation, deciding whether or not you're going to proceed in paying on a claim or going to deny a claim. The decision to retain a biomechanical engineer certainly affects litigation because by the time me as the defense attorney gets the case, if my adjuster has a biomechanical engineer retained, then I'm going to be using that person in litigation. I'll be relying on them at trial. They'll be the key witness in assessing whether or not this mild impact or minor accident would have caused or contributed to the injuries that were alleged in the lawsuit. So bear in mind that you're really setting up the case long term when you're retaining these experts. That goes for an IME doctor, that goes for hiring the biomechanical experts or anyone that you consult with that affects your adjustment of the claim. Because as an adjuster at trial, you're going to be sitting there testifying as to why you made the decisions that you made. Why did you decide to retain a biomechanical engineer 4 months after an accident? Typically, the answer is because the injury seemed out of proportion with the accident. I didn't get any bills for several months, and suddenly I'm getting bills from a neurosurgeon when reviewing the police report. It looks like there was no injury reported. The person didn't report to any kind of facility or emergency room after the impact. All that kind of information gathering and investigation is going to be what you testify to at trial. So just bear in mind that when you pick to go the route of biomechanical engineer coupled with IME, you are committed to that regardless of what the result is going to be. I often get questions as to whether or not it's cost effective or cost efficient to utilize the biomechanical engineers. Some of them can be very expensive, especially if they're utilizing a lot of their crash data, computer software to finalize their report. But certainly if there's any questions, the cost, which can go from anywhere from $1,000 to $5,000, sometimes more than that, is certainly something that you'd want to consider. Is this minor claim where it's just they went to one treatment and it's not really going to be an issue down the line as to the excessiveness, or they're not really malingering or inflating their claim? But certainly you can work with your experts and you can say, I just need a consultation, and it'll certainly assist you in the investigation part of claim handling. That's all that we've got for August 2018 Michigan PIP Monthly. Please contact me with any questions or comments that you may have. My email address is located on the slide, or you can contact me directly at my phone number listed there. Like I said, we are open to topics. A lot of people contact us and ask us to discuss certain issues that are either a hot topic in their offices or something that some of their adjusters may have been struggling with, and we're happy to talk on these points as well. Again, thank you for listening, and we'll see you next month.